Technical Session 9, Global Patent Filing and Drafting Strategies. Embark on a journey to decode the intricacies of global patent filing and drafting strategies. Explore pathways to international success in the world of IP. Allow me to introduce Mohammad Yawar Irfan Khan, Chairman, United Trademark and Patent Services. With over 2 decades in IP law across diverse regions, he's a seasoned leader in the field. You are the moderator. Yeah, I'll ask the moderator to introduce the other speakers of the panel.
Thank you very much. Can you all hear me? We are spot on time, the first session on time, so it's my pleasure and honor to session and moderate this important segment. On my right-hand side, I introduced Mr. Hattori-san. He's from Japan, the famous law firm of Nakamura and Partners. This gentleman on my right, again, not need any introduction. Tarun is a very vibrant and dynamic patent attorney and a lawyer in India. On my left-hand side, I have the pleasure to introduce Vidya Vikas. She's the lead from Tata Consultancy in India. And on the extreme left is Chandani Agarwal. She's the head of international patent and strategy from the Google company. So, ladies and gentlemen, with these words, I would request Hattori-san to please embark upon his presentation. Thank you very much.
Thank you very much. Great introduction for me. I'm Hironobu Hattori from the Nakamura Partners in Japan. So I wanted to explain about how to draft the global patent applications. I'm not a US attorney or EP attorney, but I will try to explain based on my experience today. So before starting, so how many cats in this slide, the art? This is a very old art in Japan. And yeah, you will see the face of cat made by 9 cats in here. So this is similar to the how to claim for the invention. So if you see the invention, you have you need to see that from the different angles, aspects. Sometimes focusing on that or widely range and to create the claims. Always invention is your mind, the inventor's mind. So we need to draft the inventor's mind out from the mind to write down the claims. So we need to write down various kind of claims. So usually the invention is a compound A. So we first claim the compound A, of course. And also we write down the method for producing compound A or something. But there's some variety of claims, like means plus function claim or product PVP claim. So those like means plus function claim is sometimes used in the US, but the range of the protection is a little limited. But still, you should try to have that kind of different angle of claims. Product by claims is actually not used in Japan, not allowed in Japan. But still, you should write down in the specification or claim about the product by process claim. This is one of the varieties of the claims. And also, like specific usages, like tire comprising A or car comprising using the compound A. Those wider range of the claims is sometimes useful to having a remedy or getting a huge damage. So we are trying to various kind of claims for those kind of drafting the claims. So other tips for the claims is the use limitation. Use limitation is very useful in Japan. Even the compound A is known. We can still have a claim like composition for use a tire. So the usage of the tire is new, even compared to the compound A. Those claims sometimes allow in Japan or Korea, and not in US, but you can modify the claims like claim A1, a tire comprising compound A, or in China, claim 1B, use of compound A for making a tire. Those are also sometimes allowed in those countries. So there are space to have the protection for those use limitations. Even in India, you have a section 3D, and there's no chance to getting that kind of the usage limitation, but you should try to have those claims. A number of claims. Usually we have 20 claims in view of the US practices, and sometimes 15 claims for EP practices. And in Japan, we are recommending to have 30 or 40 claims in view of the amount of the fees for examination. Lastly, unity of invention. So you should have important claims for the first. Even you have a lack of the unity of invention, you can examiners always examine the case, the claims for the first claim only. So you should have an important claim on the first. So second, the specification. You should have a variety of description in the specification. First one is a use or the term or instead of the preferably. Sometimes we see in the specification, like for example, 1 to 90%, preferably 5 to 80%, more preferably such and such. But there is a problem in Europe. So if you have 1 to 90% claim in the specification, you cannot amend like 1 to 50% because 50% is in the more preferable part. You cannot combine those 1% from the, for example, 50% from the more preferable functions. So I always write the specification like 1 to 9, 1 to 8%, 1 to 50%, blah, 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 or something. Then you can get one of the range to claim up. And the second one is do not rely on the incorporation by reference. So this word, phrases, can be used in US. And sometimes the Article X is incorporated by reference, and you can amend some words and terms from the Article X, but that is not the case in Japan. So you should disclose everything written in the Article X in the specification. So last one, provide clear definitions. Like if you use about, you should describe in the specification what is about, like plus minus 5% or 1% or something. And the second one is particle size. If you have a particle size, there are a variety of measurement methods. You should decide what is a measurement method. The lastly, I'm going to show you the comprising word. Comprising usually used as an open-ended claim, open-ended phrase. But unfortunately, in Australia, comprising is the meaning of exclusive or exhaustive, which is close-end. So you should describe in the specification what is a comprising. Comprising is inclusive meaning. Then you can have a open-end meaning for the comprising. So those kind of things should be described in the specification. So for the last one example, so I wanted to invite my colleague, Mr. Fujishiro, to explain about the importance of the examples.
So I'd like to talk about example. So we recommend including at least one example. So Japanese examination guidelines state that examples shall be used if necessary to explain the invention. So the examples are not compulsory, but actually strongly advisable, especially for chemical and biological invention. So Japanese examination guidelines also state that when an invention pertains to a technical field such as chemical compounds, where it is relatively difficult to understand how to make and use, normally one or more representative examples are necessary. So namely, importance of examples may vary depending on predictability of the technical field, but in any field, examples are useful to prove the effect of the invention, or how to carry out the invention, or how to solve the problem. So, and it should also be noted that in Japan, there is less chance relying on post-filing data than other jurisdictions. So this table shows 3 court cases in Japan. 2 relate to inventive step, and 1 relate to support. And in the inventive step cases, the court allowed post-filing date in the old case, while in the recent case, not. So these 2 cases are similar in that effects are merely literally described, but no experimental data are shown. So the court seems to become stricter. And in the support case, the court did not allow the post-filing date. So in general, in Japan, the post-filing data is less likely to be taken into consideration in the examination of support than inventive step. So for support, it is needed to show that problem to be solved can be solved by the whole scope of the claimed invention based on the disclosure of the specification as well as the common technical knowledge. So post-filing data can be only support of the specification or the common technical knowledge and cannot exceed the content of the specification. The literal description of the effect may not be considered as the substantial content of the specification. So in view of this strict Japanese practice, we recommend including at least one example so that you can rely on actual experimental data. Yes, that's all. Thank you.
Thank you very much. I would now request Tarun to please take the stage and exchange his knowledge at par, what he has been doing over the years and in this field. Thank you very much.
All right, a very good evening, first of all. I'll not make a formal presentation. We've been asked to wrap up by about 5:30 or so. So what I was thinking and what we had jotted down here were certain pointers that we from our personal experiences believe should be considered at the time of drafting of patent applications, and these are all points that have actually come out of our learnings from opposition proceedings that we've been a part of, patent opposition proceedings, and also revocation petitions that we are sort of arguing on either sides. And when our own drafted patent applications are getting opposed, what kind of objections or grounds of opposition are being raised by the other side is what I thought I'll give a very brief summary of, and which may help to keep these points in consideration. We are not here on lack of inventive step or novelty objections, because they are very fact specific and cases specific to the respective case. But I think one thing which is increasingly being relied upon by opponents these days, including when we file oppositions, is a very clear ground on lack of sufficiency, where we very clearly target the patent applications on every aspect of the claim and try to depict from the spec that the specification lacks sufficiency on that particular aspect. Which, for example, if the center disk in a wheel architecture, the disk is attaching to a rim, the manner in which it is attaching it is, if it is not described in the spec, is an argument that we will surely try to very heavily emphasize upon, even if the applicant on the other side will come back and say that this is and would be known to the person having ordinary skill in the art in terms of how to attach it. But every single limitation in the claim that we do not find implementation or sufficient description for will at least take a lot of our time in terms of while we are drafting an opposition an opposition matter in that case. So I think it is very critical that we write as many embodiments and examples as possible, so that at least for the main limitations of the claims that we have in the independent claim and or other claims, if there is tomorrow a question on where was this described, we can actually take him to para 35 or 72 or whatever that it might be. So for the claimed subject matter, there obviously would be a lot of matter which is not claimed. So we can at least leave that alone, but for whatever is claimed, for every limitation, we should in a way have a direct reference that this is described here and that is described here, for instance. Same also goes when we are talking about an objection that comes in the software space on section 3K, where we are asked to indicate what is the technical problem and the solution being focused upon. And then instead of arguing, if we can actually take the controller to a particular paragraph which in the background section, or even in the specification early on, if we have mentioned and described that this is the problem that we are solving, read para 25 to 31 for instance, and this is the solution which is technical in nature. This is how the invention has a technical character, is improving the performance or reducing latency or whatever the technical aspect would be in terms of even training a neural network, for instance. All of those aspects we should, instead of arguing, if we have it in the spec, I think it saves a lot of time and gives the controller on the other side a lot of confidence that the specification was well written, well described, embodiments are exemplified in nature, and therefore even from a 3K perspective becomes easier for us to showcase rather than just a common reference number in the drawing. And there were two completely different ways of implementing it. Obviously, in the larger scheme of things, it was the same inventive step, but because it was where, for example, in the same context of a disk being attached to a rim, now you're attaching in one embodiment at one portion, and in another embodiment, you're attaching the same disk at another portion of the rim. Now, by virtue of there being two different portions, they cannot be marked as or referenced as the same element number. It can't be 520 there and 520 here, because the portion in terms of the area at which they are joining becomes different. So I think it is also important that in the interest of clarity, instead of maintaining the same reference numbers of drawings, like 520, 350 or whatever that number would be nomenclature wise, keeping it across all examples the same may create confusion tomorrow even from an enforcement perspective, because you will then have to substantiate whether the 520 being referred to in the claim is from figure number 1 or is it from the embodiment of figure number 3. And therefore, preferably for clarification purposes, if your reference numbers are different across different figures, it will bring clarity, and you can, while claiming, mention that reference number so that there is the easier correlation, because Indian controllers do usually require the claims to be written in an omnibus manner and that you enter the reference numbers. So unless you have a single claim in which you want all the variations to be covered, in which case obviously then you have to put 520, 530, 550, which are across three different figures. But if you only want to target one figure and claim that as one independent claim, better to have a different reference number rather than have a common one. And this is something that we are fighting very aggressively while filing a revocation petition against another applicant, which actually across two different figures refer to the same reference number. I think consistency of language and clarity therefore becomes very important. I think once you've used a term, you use it consistently. We also see several applications while dealing with oppositions where a tort becomes another nomenclature, and then the nomenclature across paragraphs or variations keeps changing. So that again becomes a very clear ground for us to target the clarity, which is an argument which is different from sufficiency, because the specification may be replete with examples, but then by virtue of every example using a different nomenclature, it may have clarity issues, and both of them being independent and different grounds on which an opposition can be fought across. Also, when we are drafting a patent application, I think most of us are well versed that when we are drafting a software case, it is highly advisable to draft applications from the server side perspective. So rather than writing a claim which is allowing a user to enter into some portal or some user interface and him to do certain actions, the claim, if written from a server perspective or from a backend perspective, that there is a processor operatively coupled with the memory having instructions which when executed cause the processor to, and then you write certain steps. It's much better that we write these steps from a server perspective so that the server receives a set of data packets, identifies the header information, and extracts some other information basis that header from the cloud or whatever, and then gives it back to the user. So rather than writing the claim from a user perspective, which will make it more objectionable under section 3K, we, at least within our practice, highly recommend everybody in the firm to write claims which are server oriented, where you receive some packets and then you process it in a novel manner and then return the data packets out. So that enables you to a great extent, overcome and counter an objection under section 3K. Also, I think claims which have means plus function, as Hattori-san was also mentioning, will become difficult in India. So ideally, there should be a proper structure or construction of a device that enables a particular function to take place. But when we get applications from national phases and applications have a mechanism to do this or a means to do this, in 9 out of 10 cases, you will have objections from the Indian Patent Office stating that unless there is a structure mentioned in the spec that corresponds to that means very clearly, we are likely to get objections from the Indian Patent Office. So if we can amend either during the response to the examination report or during hearing or even before through a preliminary amendment in a manner so that we can actually replace the term means and show its support in the spec that, okay, this means corresponds to this device, which when coupled with this another tangential arm, for instance, enables this function, it makes the device plus function claim much better, clearer, and easier to get an allowance for, rather than using terms like means or mechanisms which are subjective, therefore in nature. I think also it was pertinent to mention that the standards for claim amendments have over the years, especially in the last 2 years, have eased out. So earlier when we used to recommend to foreign applicants of amending claims, it was all about within the set of claims that were filed in India. But now obviously owing to series of judgments which have come out of the Delhi High Court in particular, I think the standards have surely eased out, where till the time the amendments that we are now making to the claims are well supported from the spec, we are in a good shape. And same goes for divisional applications as well, where earlier I think it was a unanimous view that you can only divide an application in the divisional when the divisional set of claims are supported by the earlier filed set of claims, which also is not the case anymore. Till the time the divided set of claims are supported by the spec as filed, you can actually go ahead and file divisional claims as well, even if they were not in the preliminary or the early first filed set of claims or the PCT published set of claims. So I think even while filing divisional applications, it's very critical, because a lot of foreign associates believe that there is a slightly diminished value to non-unity, which is associated because the standards in the US, for instance, aren't that high. So I think it's very imperative that we, guidance be given or, clarity be given that divisionals in India would only sustain when there is clear support, to a clear argument to sustain that this is a distinct invention that does not have unity with the original set of claims, for instance. So I think that is also an important, because the standards in the US are lower than this in terms of the non-unity not really being a ground required to file a divisional application. So I think that was about it. Divisionals easier to obviously amend claims now, and we encourage obviously all our Indian clients to also participate in US examiner interviews. So a lot of the new clients are not aware of attending interviews, and that being a very easy way in the US particularly to get allowances. But in our limited experience, we have seen fascinating results of doing an examiner interview sooner we receive the first examination report, and doing an interview explaining what the invention is. Sometimes you get a very clear go ahead then and there itself, and or you propose certain amended set of claims, and if they say a yes, then you can actually avoid a good set of 2 or 3 office actions for the clients. And similarly, the guidance on, I think, continuation applications versus continuation in part are also very important, because certain clients want a very broad claim but are going to file RC, and then another non-final comes in, another final, and by that time they would have survived about 4 or 5 office actions. And if they would have lived with perhaps one narrower granted patent, and then after that patent got granted, filed a continuation application with the broader one, I think is another strategy that should always be contemplated, so that we can at least in 1 or 2 office actions try to get the first patent quickly, and then file a continuation with a broader set of claims. So I think those are small points which practically, I think, help efficiently getting IPs in India or patents in India. Yeah.
Thank you, Tarun. I can bet that the 60 or plus participants, no one blinked, but few were on WhatsApp, but they also followed what the master class was about it. Thank you so much for the in-depth. With my 80% trademark practice, 20% patent, you have indeed inculcated a spirit of doing more patents for me, at least in the coming days. Thank you very much for your master class. I would request Chandani to please take your session on board and highlight the participants about it. I go like this, okay? Yeah.
However you want. Okay. This is audible to everyone? All right. Right. So I lead the international patent strategy for Google, and whenever it comes to strategy for patents, I find it very interesting and challenging. Because for patents, like when you're strategizing, you're always thinking about 3 years from now, 5 years from now, and in some jurisdictions, 7 years from now, sort of thing. And it's interesting because the business can come back to me and say, you know, we are going to be manufacturing, let's say the hardware business comes back and says, we're going to be manufacturing now from 2025 in India and Vietnam as well. I'm sure we have patents there. Like, I have asked you every year and you never said anything to me, and in my head I'm thinking that's not how patents work, but it's not a 101 session on patents. So a very interesting kind of, you know, how to make sure that you have a strategy in place internationally to cover what the business may want to do, right? Because our goal as in-house is freedom to operate for our business. The business should be able to do what it wants to do, whenever it wants to do, and wherever it wants to do it, right? And patent is a tool to help make that happen, right? So the challenge within that that's interesting to me and that I deal with is, where should we be filing? You know, what are jurisdiction? And as you can imagine, with a company like Google, like a conglomerate with so many technologies, products, different types of products ranging from software, hardware, cloud, phones, you know, OTT kind of services. How do you make a strategy that works across Google as well as is customized to each different product area, right? So there are 3 broad things that we look at when we try to decide what jurisdictions we should be focusing on and how we should be going about it, right? The first is the business context, and I'll talk a little bit in detail about each one of them. So the business context is the first and foremost important. The second is the legal context, and the third is the country context. So when I say business context, what it means is how is Google for that business investing in a particular jurisdiction? What are the revenue for Google product area in that jurisdiction? How are users in that jurisdiction? Similarly, then we also, for the business context, each business has different competitors, as you can imagine. So we benchmark against our competitors, right? How are the users going for companies we consider our competition in different countries? How is their revenue going up? What are their users? And in addition to that, we also try and look at, like, do we have data centers? Are we investing there in terms of significant partnerships? For example, a couple of years back, Google announced this huge partnership with Reliance in terms of phones, right? So are these kind of things, billion-dollar deals happening, right? Are we thinking of manufacturing in those countries? So what does the business want to do is the first and foremost important kind of indicator. The second would be the legal context of the country. So if you kind of want to think about how many patents are anyways filed in that jurisdiction, how many is Google filing, how many are competition filing, how does the litigation landscape look like? So there are some jurisdictions where you can't get injunction, where there's no scope for damages. So does it really make sense to have a heavy patent portfolio there if the legal system does not support what the outcomes we would want to have when the rubber meets the road, sort of a situation? So definitely the enforcement system, like the legal context of the country. Then the third one is the country context. So interestingly, we also looked at GDP growth for different countries because, as I said, like, it's kind of a long game. So how are things going to be 5 years from now? So in APAC, the countries are going to reshuffle in terms of how they rate on GDP right now in the next 5 years. 2030, India is going to be much higher versus, and some others are going to go down. So we also take that as an indicator of where we think, you know, that will happen. Plus we'll have the business would want to go there. And the political system, is it on a downhill or uphill in terms of, you know, like, will it support what we would want to do? And then also make sure that, you know, we do filings. We kind of come up with a score. We can do it as heavy lift as you want with this. You can also go external and ask for consultants and do a lot of different, you know, what litigations are going to happen. Are there litigations happening in these jurisdictions? How are they handled? And you can also go very light on this, but kind of look at all these things and make a decision for yourself. But I feel a lot of these factors definitely make sense for each different company or each different product technology. So we look at all these different things and then we try and come up with what are our first tier of jurisdiction, second tier, third tier, and then also provide customized kind of information for each product area. If, like, for example, we have like a Google-wide jurisdiction list, and then we also have something very specific for hardware. Because maybe Vietnam and Thailand or Taiwan are going to be important for hardware, but not for other product areas. So those are the different things we look at while deciding where we would want to file. Yeah.
Thank you very much, Chandani. You took me back 40 years when I was in the business school. So we learned all these plannings and submissions before the business community and the entrepreneur. I would now hand over to Vidya to exchange her experiences and strategies.
Thank you, Mr. Yawar. Good evening and a warm welcome to all. Last session, I'm sure everyone is tired. I hope I can do justice to the time you're spending over here and add some value to your time here today. So most of my co-panelists have covered almost every aspect of the topic that we are discussing today. I would be specifically speaking about the challenges that we see when we are drafting on filing patent applications in the emerging technology domain. So as we all know, technology today is moving at such a fast pace that the shelf life of any technology is very hard to predict. I mean, the amount of time, effort, cost that we invest into any technology, we wish we knew, we could predict the shelf life for that. But unfortunately, it's not the case, right? So what is the best thing that any innovator, any organization, any individual would want to do? Capitalize maximum on the investment made into a particular technology. Right? And the best way to do that, of course, among all forms of IPR, patent being the strongest one, the best solution would be the first to innovate, be the first to market your product, be the first to file. In every aspect, you need to be the first. So having said be the first to file, you also want to be the first to get a grant, assuming many have filed on the similar timelines, right? Now, there was a time when we could see our R&D effort culminate automatically or organically into a patent specification. But today that is not the case. And why that is so is because a patent attorney's role has become very important. It's not just enough to adhere to the statutory requirements of various jurisdictions that you are going to pursue the innovation in. It is very much essential that you craft your specification in such a way that it adheres to the emerging interpretations of eligibility across the world. So my colleague here spoke about the different jurisdictions, my colleagues over there spoke about the drafting strategies, that these requirements are even more critical when you're looking at emerging technologies. Now, if we were to look at what are the top 10 emerging technologies, right? You have like forums like World Economic Forums, or you have various technology analysts who publish the top 10 or the top 20 technologies every year. In the past, what we would see is that there would hardly be any change in the list. What you would see is there would be a little change in the placeholder. Something that was first in the first 5 probably came down to the next 5 and so on. But today what you see is there is change. Or I would say sometimes there is a drastic change, or sometimes there is an evolution in the technology. Like for instance, if we spoke of AI last year, now you're speaking of specifically of Gen AI, right? An evolution, but specifically a subset of a larger technology. So with the digital transformation that we see today is completely fueled by these emerging technologies. So when you're not able to predict what is going to be the next relevant technology in the market, seeing these trends, what is more challenging is when you're drafting an application today, you have to wear the examiner's hat, not knowing what is going to happen 2 years down the line, 3 years down the line when it comes for prosecution. And that is the biggest challenge that we face today with emerging technologies, precisely because of the lack of clarity in what would stand valid tomorrow. For instance, if we were to look back in 2015-16 when Alice versus Banks came out, it was like a death sentence for computer related inventions. Today, the similar challenge I feel would be, of course, with subject matter eligibility, but also with clarity, some of which Tarun and my other colleague here touched upon, because there is no idea on how much is enough when you talk about emerging technologies. Let us take AI for instance, right? Now, when you talk of artificial intelligence, if you're looking at innovations in the narrow space, if you look at innovations there, the current jurisprudence and the case laws that you have, the act that is prevailing seems to be adequate. But the minute you foray into general intelligence or super intelligence, as far as artificial intelligence is concerned, then it's a black box, because you do not have clarity on the reasoning and the inferencing capabilities of the machine. So why is AI so important today? With Industry 4.0, we have, completely changed the way we interact and exchange information. Machine and human beings alike are generating such a humongous amount of data. And data, as everyone today says, is the new oil, right? So you want to draw meaningful insights from this data. You want to be able to identify patterns from this data. You want a return on investment on all this data that is being generated across the world. Human mind can definitely do that. Even today, research maintains that the human mind is unrivaled in its capacity to perform analysis or objectively work, rewire itself as compared to the supercomputers of today, and much more energy efficiently. I brought in energy efficiency mainly because we all know how many zillions of fresh water ChatGPT training alone consumes, right? So the human mind in that sense is very energy efficient. But what is interesting about the human mind is we never want to assume or accept that something is impossible. And that is why we see across the world there is so much of endeavor to make the machine mimic what the human mind can do. And that's where we are talking about artificial intelligence. So while all those repetitive tasks that I was talking about can be done by the human mind, it's best left to the artificial intelligence machine. So where does the problem come? So when the more and more we are trying to automate and the more and more we are trying to minimize the human intervention in these automated systems, the potential of harm to society when it is an undirected invention, the potential lack of assessment of infringement. Where is the data being used? Is it ethically being obtained? Are we indirectly, inadvertently infringing on another patentee's rights? All these are challenges that today have no answers. Can really the artificial intelligence machine be called an inventor? When we assess AI inventions, prior art becomes a big problem, especially when I'm talking about AGI and ASI inventions. So today we talk of person skilled in the art, POSITA as we refer to it. So when we look at artificial intelligence inventions, are we looking at artificial intelligence skilled in the art? Because there is no person. You are minimizing the human intervention. It's all about the machine. So where is a person skilled in the art? How do you assess inventive step when it comes to artificial intelligence, right? Now, with this blurring line between the real world and the virtual world, the next platform that we come into is metaverse, right? We had an interesting panel discussion some time back over there where quite a bit interesting problems were covered. So when you look at metaverse, if today you have challenges for, with respect to artificial intelligence in the real world, those challenges manifest on a huge and a much larger scale when you're looking at metaverse, right? Because there is no jurisdiction boundary. Sorry. My colleague was talking about how you would select different jurisdictions, right? But in the metaverse, there is no jurisdiction. So how do you decide where is the infringement? Who has the right? Everything in a digital world is created. The minute you talk about creation, the next question is who is the owner of that IP? Can a digital person, can a persona be held liable and accountable like a real person can? So these implications go way beyond the patent law. They go into civil laws, they go into corporate laws and beyond, GDPR, you name it, right? So the challenges are unending. Now, we can't not talk about generative AI. So far when we talk of artificial intelligence, we are talking about, you know, the machine doing repetitive tasks. But there is one unique skill that we as humans have, and that is creativity. Today, artificial intelligence is able to mimic even the human skill of creativity. But there was a very interesting article by by the MIT Technical Review. You know what it said is that most organizations today believe that generative AI has an impact on business. Hardly 4% refuted that claim. But the reality is that only 9% actually implemented generative AI use cases within their organization. Why is that? When you are able to appreciate the benefits of generative AI, you are not able to implement it. The reason being, there is so much of ambiguity in the implications and the risks involved. So unless we have clarity in all this, getting around to declaring we own something in these fields is quite a risk which we are not able to take sometimes as an organization. If you look at quantum computing, another emerging technology, even in that domain, you face a similar black box problem. Like the innovations would typically be around, you know, states of matter like superposition or entanglement. It's very difficult to show them in practice. So immediately you go into the realm of them being a natural phenomena, you are in that black box zone. So these are some of the challenges in the emerging technologies where there is no clarity. The rate at which we see the technologies change, emerge, evolve, the rate at which we see the business aligned to these emerging technologies to stay relevant. Unfortunately, we do not see the patent system being, you know, evolving at the same rate. with all these big problems that we're talking about, sometimes we see very rudimentary problems as well. Like for example, if you were to have an innovation in the field of computer imaging, right? So the drawings that you illustrate are going to be images which are not necessarily line diagrams. They are not necessarily clear diagrams that you would associate with traditional domain innovations. But you would still get an objection prior to examination from the administrative office that it does not comply with the requirements of the Act. It's high time these outdated laws were, actually revamped, and you can always defend it and get this rectified. It's not a problem. But what you lose in the process is precious time. Like I said, with everybody wanting to be having the first mover advantage, you cannot afford time wasted in beginning of an examination just because of these small rudimentary problems that you have. So with this, while I do present all these challenges, I would like to say that this particular year at the Indian Patent Office, we've seen tremendous response, tremendous progress as far as any form of IPR is concerned, be it patents, be it geographical indications, be it trademarks. We've done amazingly well. So there is hope. We've come a long way, and I'm sure if we all put our hats together, we would be addressing all these challenges at some point in time. With that, I close my 2 cents. Thank you.
Thank you very much, Vidya ji. It's a really wonderful food for thought, and I think R&D and research is the gateway for the patents in the future. And the mankind is the super brain. Let's see mankind innovates more and more ideas and more patents in the coming years, which is good for the mankind. With these words, I would like to open the floor for any of the questions you have from Hattori-san or Tarun ji or Chandani ji or from Vidya ji. We still have some time.
Yeah, 2 questions.
Okay.
Quick 2 questions. Otherwise, we close the session. So thank you. As we bring this session to a close, let the insights gained here fuel your journey to new heights. A heartfelt thank you to our panelists for the exceptional contributions enriching this session. Special thanks to our skilled moderator for steering this session with his expertise and insightful guidance. Thank you.